Well, despite legal challenges pending over Illinois' gun and magazine ban, Illinois State Police have opened that window for those who own banned firearms from before January 10th to register them. Welcome back. Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY, Springfield's News and Talk. And we've covered this extensively. We've still got the 7th Circuit Court of Appeals with the case challenging Illinois' gun and magazine ban on Second Amendment grounds pending, even though they heard that when it feels like months ago now. While you've got other districts across the country dealing with bans on magazines or butterfly knives, and those issues have had the plaintiffs point to other courts to say, hey, 7th Circuit Court judges, look at these other judges that are ruling in favor of the Second Amendment based off of U.S. Supreme Court precedent, and not just the Bruin case, but also in the Heller case. So what we've got now is the prospects of next week's hearing that Attorney Thomas Magg has down in the Southern District of Illinois, October 11th, on the issue of vagueness. And this is all part of the initial challenge that Magg brought forward in Crawford County State Court that was transferred to federal court and then lumped in with all kinds of other cases in the challenge against Illinois' gun and magazine ban. But they advanced the challenge on the Second Amendment. And again, I want to make clear that that's what's being heard and considered in the 7th Circuit U.S. Court of Appeals, the Second Amendment challenge. But Magg's challenge initially had not just the Second Amendment, it also had the Fifth Amendment, the right to not incriminate yourself, and also a challenge on vagueness grounds. When we've talked with Magg in the past, he addressed ultimately what his thoughts are on vagueness issues and more.
Of course, the 7th Circuit still has the Second Amendment issue vis-a-vis the temporary restraining order. The case that I originally filed, the Langley case, also included claims of unconstitutional vagueness, as well as Fifth Amendment claims, because it requires persons to register firearms and potentially incriminate themselves.
So the vagueness claims are going to be heard October 11th by Judge Steve McGlynn in the Southern District of Illinois. McGlynn is the same judge who issued a preliminary injunction on Second Amendment grounds, and that injunction was only for 6 days. Some in the pro-gun rights community say that was Freedom Week. They had a 6-day window where they could go purchase firearms because the court put an injunction on the law for those 6 days. Very similar to the state level cases that Tom DeVore had, a temporary restraining order for thousands of plaintiffs that are clients of DeVore. Those temporary restraining orders allowed them to go and purchase semi-automatic firearms and magazines that were banned for everyone else. So, the idea of having that 6-day window coming out of Steve McGlynn, now he's going to be hearing this challenge on the vagueness issues, October 11th in the Southern District. It'll be interesting to see if he rules from the bench, an injunction, or if he sits on it for a few weeks and then rules one way or the other. But obviously, this is something that Magg, the attorney who brought the case on Second Amendment, Fifth Amendment, and vagueness grounds, he will be making his arguments about vagueness. And one thing he says is in Springfield Armory versus the city of Columbus, it was already shown, the court found that the city's ordinance there, this is back in 1994, the ordinance that the city of Columbus had banning certain assault weapons by brand name without including within the prohibition similar assault weapons of that type, function, and capability, it was not rationally related to any legitimate government purpose, they said. So in Springfield Armory versus Cleveland and the United States Court of Appeals, the Sixth Circuit stated that ordinary customers cannot be expected to know the developmental history of a particular weapon. So that is something that Magg's pointing to highlight the vagueness challenge, and that's going to be heard October 11th. If the vagueness challenge doesn't work, Magg said he's going to pursue that Fifth Amendment challenge.
Fifth Amendment challenge will probably follow very shortly on that, depending on what the vagueness ruling is out of Judge McGlynn. But we're very confident that the court, pursuant to the Sixth Circuit Court of Appeals case from several years ago, the City of Columbus case, Springfield Armory versus City of Columbus specifically, we'll find that the firearm and magazine ban is, if not completely, is at least largely unconstitutionally vague.
So again, those vagueness arguments going to be heard October 11th. MAG says that with the window open, some people may be voluntarily violating their Fifth Amendment rights, and that's why it's so important that this gets settled and an injunction is in place, he said.
Frankly, we're really concerned when this whole registration period starts, if it's not previously enjoined, that with the vagueness, with a whole host of issues, that people will be incriminating themselves, just as set forth in the U.S. Supreme Court case of 1968 of U.S. v. Haney's.
So there, the National Firearms Act of 1934 required the registration of certain types of firearms, and the Haney's v. U.S. case, it was of a convicted felon who was charged with failing to register a firearm under that act. Haney's argued that because he was a convicted felon and thus prohibited from owning a firearm, requiring him to register any firearms in his possession was required to make an open admission to the government that he was in violation of the law, which was essentially a violation of his right to not incriminate himself. So ultimately, you had the courts say, yeah, the decision blocked state prosecutions of criminals who failed to register guns as required by various state law gun registration schemes. So it'll be interesting to see how that plays out if indeed we get to that Fifth Amendment argument as MAG attempts to try to put a injunction on the state's gun and magazine ban. But what happens if the gun and magazine ban is upheld? Well, you've got some legislation that State Senator Jason Plummer has that would ultimately allow for those who did purchase firearms after January 10th, but only as being under either a temporary restraining order that, say, Tom DeVore was able to get for his thousands of plaintiffs, or that the Judge Stephen McGlynn issued a preliminary injunction for that 6-day window for the entire state, what gun rights groups call Freedom Week. Jason Plummer, he wants to make sure that there are protections for those individuals, because right after that stay was issued on the Southern District Federal Court's injunction, you had state police come out and say that firearms purchased during that 6-day injunction window cannot be registered by the January 1st deadline because they were owned and possessed and purchased after the law's enactment date of January 10th. So essentially, if you were somebody who went out and purchased a gun in late April, early May, then that gun cannot be registered come January 1st, the deadline, and it's an illegal gun, according to state police. So Jason Plummer, he has a provision that he wants to get passed during veto session that says, listen, these individuals who purchased these should be held harmless because they were just following the law as was spelled out by court orders, either in state court with temporary restraining orders or in federal court with that 6-day window of a preliminary injunction.
It's not something we've given up on, because I think the closer we get to January 1st, the more obvious the problem will become to more people. As far as the first-time gun offender program, it's effectively a get out of jail free card to a lot of people who are committing crimes a lot worse than the entrapment that the governor is trying to put them in. So I have grave concerns about that legislation, and I don't think that that's ultimately a great long-term fix for people who may or may not ultimately get caught up in this. I hope that we can resolve the matter for the folks who've been caught up, before January 1st, and the get out of jail free card for people committing crimes, with guns is a whole other story.
So obviously, Plummer, when we talked with him a while back, really is, looking to get his measure that holds people harmless if they did indeed purchase firearms during that 6-day window, or if they had temporary restraining orders in place. But he also there commented on the idea of, the first-time gun offender program that was extended during the spring session, and the governor approved it, that says, hey, if you're a first-time nonviolent offender, you can have a diversion program in place. Is that going to impact these individuals who are going to be found outside of the registration? We shall see. But if the law is deemed unconstitutional, a measure from State Representative Amy Ellick, House Bill 4150, this was filed on Thursday, and here's what it says according to the state legislature's website. It provides that should provisions regarding manufacture, possession, delivery, sale, and purchase of assault weapons, 50 caliber rifles, and 50 caliber cartridges be found to be unconstitutional by a court with all appeals exhausted or expired, the Illinois State Police shall immediately and permanently destroy or have destroyed each endorsement affidavit and all information collected from the endorsement affidavit in possession of the Illinois State Police and any law enforcement agency. So again, there's two different tracks there. That either if it's upheld, then Jason Plummer wants to make sure that those who purchased firearms during that 6-day injunction or with temporary restraining orders are held harmless. Or if the law is found unconstitutional, then the state police should destroy all such records. But all of this, of course, still pending in courts, in federal courts, and even Tom DeVore has brought his case back with a motion to reconsider after the Illinois Supreme Court found the Calkins plaintiffs did not prove their case on the issue of equal protections. So just to recap here, all right, and I know there's a lot here. Still pending out of the Seventh Circuit Court of Appeals, the challenge on Second Amendment grounds against Illinois' gun and magazine ban. That's still pending in the Seventh Circuit Court of Appeals, federal court. In the Southern District Federal Court, October 11th, that's next week, Thomas Magg, he has his challenge on vagueness issues. If the vagueness issues don't produce a preliminary injunction, he's going to bring up the Fifth Amendment argument. So that's in federal court, Southern District. Steve McGlynn, same guy who gave that injunction. Well, you also have Tom DeVore seeking a motion to reconsider his case in state court, and that's on equal protections grounds. All right, so several different arguments, 4 different arguments. Second Amendment, Seventh Circuit, Southern District of Illinois, vagueness, possibly Fifth Amendment. And then in state courts, you've got DeVore bringing back the issue of equal protections because the law does not impact police, retired police, jail guards, prison wardens, those in the security sector, and so on. So that's the equal protections argument. But if the law is upheld, Jason Plummer wants to keep people safe who purchased during the 6-day injunction window or with temporary restraining orders from allowing them to register those weapons, even though they were purchased after January 10th. But if the law is deemed unconstitutional, then Amy Ellick has her bill that would require Illinois State Police to destroy any and all records that were collected via the state's gun registry. So that's where we're at right now. All right. And of course, that registry opened up October 1st as these cases are still pending.